Gentlemen, uh, my apologies for my lateness, but the traffic in this city is getting worse every day. Anyway, the hearing of the Committee on Public Works, joint with the Committees on Justice and Human Rights, Ways and Means and Finance, of Tuesday, 10 March 2015 is called to order. We are resuming the suspended hearing of May of last year. So let me just acknowledge the presence of those resource persons who are here today. From the Department of Public Works and Highways, Attorney Camilo Foronda, Engineer Sonny Macasir. From the DOTC, Attorney Jonathan Dirain. From DOJ, Attorney Shai Marie Sandoval. From the DILG, Ms. Minerva Sanoria. From the DOE, Attorney Ben Julius Gagni. Gagni? Is that the correct pronunciation? From the DNR, Ms. Emeline Talabis. From the NEDA, Engineer Elmer Dorado. Oh, hello. From the HADSI, Mr. Cromwell Teves and Ms. Crystal Matias. From the OSG, Attorney Omar Diaz and Attorney Omar Romero.
Good morning, Honorable Chair.
Good morning. From COA, Ms. Julian Lasso and Mr. Renato Rosales. From the BIR, Attorney Nina Asuncion. And from the PPPC, Attorney Joanna Geronimo Ansares. And from the Toll Regulatory Board, Attorney Arias Mejia. And just arrived is Mr. Lito Madrasto, the Executive Director of the Philippine Constructors Association, Inc. The agenda today is the continuing hearing on the Senate Bill number 2145, which I filed, and Senate Bill 2180, filed by Senator Lito Lapid. But we have, in addition, now a bill that was filed by Senator T.G. Gingona last November, which is the Senate Bill number 2447, an act to enable government infrastructure projects and public-private partnerships projects by amending Republic Act number 8974, otherwise known as the Act to facilitate the acquisition of right-of-way sites or locations for national government infrastructure and appropriating funds therefore. I trust that all the resource persons have familiarized themselves with Senate Bill number 2447. So I will just go down the list and we have your positions on the two other Senate bills, 2145 and 2180, that we covered during the last hearing. But now, as I said, there is a new bill that has become part of our agenda. There's a new proposed Senate bill that has become part of our agenda. So I would like to go down the list and of our resource persons and get your opinion. I'd like to acknowledge the arrival of Senator T.G. Gingona, whose proposed Senate bill is the subject of our hearing today.
Morning, Mr. Chairman.
I was just going to go down the list and get the position paper on your bill. Do you want to say something? All right, so we'll start with the DPWH. Who would like to sino magsalita? Ikaw na, Attorney Foronda.
Yes, Mr. Senator.
Mr.
Chairman, our comment to House Bill, Senate Bill 2447 is almost the same as House Bill 2994. And we fully support Senate Bill 2447, Mr. Chairman.
Okay, but there are several I think the main feature of the bill is the method and the designation of expropriation as the preferred, or rather, yeah, the preferred option. Yes, yes, Senator.
Yes, Mr. Chairman. It's a preferred option, although it's not the first option. It's just a preferred option. And then the landowner will first be given an offer based on the standards, and then after a period of 30 days, the implementing agency can initiate expropriation proceedings. Should he either refuse or snub the offer of the agency? So this will cut down, Mr. Chairman, the time, no? Just make an offer after 30 days. Kung ayaw niya, expropriation na tayo.
Yes, thank you, Senator Gingon. Essentially, all of these efforts are to make the process faster, because there are the statistics that we have show that the time that it takes for any implementing agency to gain right of way is becoming more, and well, the process has become more and more involved, and secondly, and because of that, the time that it takes is becoming longer and longer, to the point that some of these projects actually get canceled because right of way is never acquired, at least not in the time that we are given. So there is nothing wala na kayong dadagdag, Attorney Foronda, dun sa...
Actually, Mr. Chairman, as I have said earlier, House Bill, Senate Bill 2447 is similar to House Bill 2994, which is already ready for plenary debate, Mr. Chairman, which we supported, fully support. House Bill 2994.
Yes, but that is not
Yes, yeah, but it's similar. The Senate bill filed by
okay,
TD
maybe you
was,
can
similar.
give us your position on the bills that are before us.
We have already.
Because the House bill you're mentioning is not a subject of the hearing. Before you proceed, I'd like to acknowledge the arrival of Attorney Sherian Austria, the Deputy Executive Director of the PPPC. Welcome. Yeah. Look at this. I don't even...
Mr. Chairman,
Senator Gingon.
another feature of the bill, of Senate Bill, what number is this? Of the proposed Senate bill, is that the implementing agency can remit to the local government unit the taxes, the unpaid real property tax subject to deduction.
Also, there is a feature on the payment of the capital gains. I believe,
Yes.
We're now you're giving you're putting the capability to the implementing agency to pay the capital gains tax and to immediately also...
Yes, so that it does not become an excuse to
Yeah.
to delay the...
Very well. If that, if the DPWH has expressed their support for essentially what are the same bills, then I guess we will just have to go eventually to the detailed language of this, and of course we will be trying to tap you on that for that process. From the DOTC, Attorney Dirain.
Mr. Chairman, based on our position paper submitted May 26, 2014, we support Senate Bill number 2145 and Senate Bill 2180. However, we reserve our submit the position paper for Senate Bill 2145, sir.
No, 2447.
2445, sir. The Senate bill
2447.
filed
Wala
by-
pa kayong position.
Wala pa po, sir.
Kasi yun lang naman ang mga features na medyo na may pinagbago dun sa dalawang Senate bill na nandyan. So, okay, we will await
Mr. Chairman.
yes, Senator.
Then there's also one more provision, no? The implementing agencies are empowered to provide financial assistance to the informal settlers. Kasi nangyayari dati daw, pagbigay ng financial assistance, nadidisallow ng COA kasi walang legal basis. So ngayon, lagyan natin ng legal basis so that COA will not disallow it, Mr. Chairman.
Well, again, we are still waiting for these position papers, but we must. I think that since you have already provided, we are in receipt of position papers from the DPWH, DOJ, BIR, and the TRB. I would just like the position papers from the other agencies that are present, that are represented here today, but to include the salient features that are essentially different from bills 2145 and 2180, which are themselves quite similar one to the other. But there are very significant features to 2447, which we need to hear about. So, from the DOJ, Attorney Sandoval, perhaps you could give us the position of the Department of Justice.
Yes, Your Honor, please. We also have the position paper dated May 29, 2014, which also covers SBN 2145 and SBN 2180. Insofar as the SBN 2447 is concerned, we support the provisions, Your Honor, seeing as they do make ways to expedite the expropriation proceedings. We note that there are some sections which are not in the other bills. For instance, Your Honor, and Section 10, entry into private lands for subsurface or subterranean works. Your Honor, it is the suggestion of the department that we should consult with the DNR if such intrusion is, if such entry would be intrusive if it is made more than 15 meters from the surface. And we also note, Your Honor, that there is a transitory clause under Section 14, and we feel, Your Honor, that this is a welcome development because it becomes clearer now as to what guidelines would be applicable to transactions.
Thank you, Attorney Sandoval. From the DILG, Ms. Sanuria, I think there are some features now of 2447 which involve local governments in terms of the remittance of taxes to the local governments.
Yes, DILG has prepared a position paper which is currently being reviewed by Undersecretary Attorney Enrile. Now, upon approval or signing of the final copy of the position paper, we will immediately transmit to the Senate. but as of now, this is not for quotation. I have with me the draft position paper, but being unsigned yet or approved by, not yet approved by our undersecretary, so I am not in a position to quote any of the provisions here, sir.
Well, anyway, since you have a draft, can you give us some of the opinions or the insights or that you have?
In summary, for the three Senate bills, 2145, 2180, and 2447, the ILG has focused on Section 8, which is the
on Section
8, which is the provision on informal settlers. But generally, our recommendation is to consult with the leagues of the LGUs.
to consult with the, I'm sorry,
Various leagues.
Leagues?
Yes, sir. Of the municipalities, because they are the ones who will be implementing the law. So it might as well be we will be soliciting their opinion. That is according to the position paper, sir.
so you are, oh wait, the main concern, because the LGU's role in the resettlement process is to provide or at least identify the resettlement areas.
Yes, sir.
Yes, and so where would what would the differences be between your position and the leagues plural?
Sir, according to, based on the position paper being prepared by our legal officers, we do not, according to Section 8, our position is that we do not object to Section 8.
Well, it lightens the load actually on the LGU. Because the LGU sometimes has difficulty or is unable to, for whatever reason, provide the resettlement areas. And that puts the onus now not only on the LGU, but to be assisted by, again, the implementing
Yes, sir.
agency. So that is that's all you have for us now.
Further discussions concerning the department, I will just take note of it and discuss with our legal officers for
Okay.
further, probably for further modification of the position.
We invited you last week pa, and you're here today without your position papers. We cannot really proceed without that. So I really wish that when you come here that you are prepared already to give us your positions, and not so far only the DOJ has come up with a position, and we are unable to proceed unless we have your position papers, because those are the guidelines which we are going to use when we are going to write the bill, write the final version. So can I please enjoin everybody to come here to be ready. So far, as I said, so far all you have told me is that you, except for the DOJ, you have told me is that you have no position paper, and it will be forthcoming in the future. But the hearing is today. The hearing is not in the future. The hearing is today. I wish you would come with something so that we could already discuss some of the details, because as it stands now, we will have to wait for all of those again. So anyway, let us go down the list. From the Department of Energy, Attorney Gagni, the Chief of the Contracts Division, Legal Service.
Good morning, Your Honors.
Good morning.
We have reviewed the previous bills, the Senate Bills 2145 and 2180, and on the part of the department, we fully support the intention of the bill to expedite the acquisition of rights of way. And Also, as to the new bill 2447, we already had initial discussions, and also we conducted initial consultations with our stakeholders, our service contract holders, and the department has no particular comments on the specific provisions, but we fully support the intention of the bills, Your Honor, please.
Very good. Thank you, Attorney Ganyu. From the DNR, Ms. Talabis, the Assistant Director.
Good morning, Your Honors, Mr. Chair. The Land Management Bureau manifested already its position during the last hearing on Senate Bill 2145. And as to the new bill, which is SBN 2447, we just compared the section that we commented on the last time, which is Section 3. So there is a difference between Section 3 of SBN 2145 and SBN 2447, which we think is these two provisions are not contradictory to each other. Yes, sir. So we support it. It will be much better, I think, if these two provisions will be combined. Kasi the Section 3 of SBN 2145 speaks of financial assistance to be given to the landowner, which is very good, considering that the landowner his property will be taken over by the government, and financial assistance is very favorable to him. And then Section 3 of SBN 2447 speaks of the mode of acquisition in case the original patent holder, his property is the one being expropriated. And also it speaks of a different situation when the patent holder is not the original. That means he is only a transferee. So, babayaran lang siya ng gobyerno pag siya ay subsequent transferee. Ibig sabihin, yung hindi babayaran yung tao pag original patent holder siya, which is okay naman kasi gratuitous kasi yung pag-transfer sa kanya dun sa original registration. But if the land had already been subsequently transferred to another title holder, ang presumption ng batas, kumita na siya doon kasi binenta sa kanya. So, ngayon, i-expropriate yun, kailangan bayaran siya ng gobyerno. So, maganda rin po yung SBN 2447. So, baka pag i-combine, mas okay po. Siguro kung...
So specific, pero you're directing your comments mostly on Section 3.
Yes, Your Honor.
Do you have any comments as to the points raised by the DOJ, Attorney Sandoval, on the subterranean development? Pakiulit lang, Attorney Sandoval, yung nasabi mo kanina.
Yes, Your Honor, please. It's under Section 10, ma'am.
10.
Entry into private lands for subsurface or subterranean works. Because I think there should be a determination if the entry would be considered as intrusive, considering that...
As intrusive?
Yes, Your Honor, please. If it would disturb the ownership of the private land, considering that there is a consideration here that if such entry is made more than 15 meters from the surface.
Meters is, oh, bakit ng 15 meters, 3 stories. 5 stories.
5 stories.
No, I'm sorry, 1.5 to 10 meters.
Your Honor, I think sa pag-public lands kasi, palagi siyang may easement. So, if the land is granted through the provisions of Commonwealth Act 141, actually, kahit talagang yung gobyerno pwedeng pumasok anytime. So, ito kasi, entry into private lands, it does not qualify whether private land is acquired through CA 141 or subsequent registration. Kasi pag CA 141, pwede talaga po, perpetual po siya. Pwede siyang i-take over ng gobyerno up to 60 meters width. That is in accordance with Section 112 of CA 141, Your Honor.
Pero that's easement. You're talking about. Oo.
Honor, if I may read Section 112. Section 112 of CA 141 states that said land shall further be subject to a right-of-way not exceeding 60 meters in width for public highways, railroads, irrigation ditches, aqueducts, telegraph and telephone lines, airport runways, including sites necessary for terminal buildings and other government structures needed for full operation of the airport, as well as areas and sites for government buildings for resident and or project engineers needed in the prosecution of government infrastructure projects and similar works as the government or any public or quasi-public service or enterprise, including mining or forest concessionaires, may reasonably require for carrying on their business.
Before you go on, how does that apply ngayon to subterranean development? Kasi it says in width, very specifically 60 meters in width.
In Section 111 also, Your Honor, all persons receiving title to lands under the
section is that?
provisions. 111.
Okay.
Under the provisions of this act shall hold such lands subject to the provisions hereof and to the same public servitudes as exist upon lands owned by private persons, including those with reference to the littoral of the sea and the banks of navigable river or rivers upon which rafting may be done.
Nothing specific. But so far from the two sections that you've read, there's nothing that doesn't. Is there anything specific to subterranean works? Because that is the point that was raised by DOJ. So far, littoral, that's sa tabing, well, that's by the water.
As to subterranean, we have no provision
There's
on
no
that.
specific provision on that.
But
Siguro we should just clarify it. Maybe you can give us your recommendations on how we should handle the, because the DNR has not, I suppose it's not something that has come up recently, that we haven't had any large subterranean developments. That's why this has not really come up. But now that marami na tayo nakikitang proposal for subterranean development, tunneling specifically.
Your Honor, perhaps we can continue with communicating with the DNR because we really have to consult other environmental laws if it will have an effect or if it would be intrusive, as in it would disturb the enjoyment of the private owners of the lands. But I understand that it's really it's quite high already, Your Honor, but we're just trying to avoid any.
For example, would that kind of development, for example, a tunnel, a railway tunnel, would that not be covered because they would still be required to acquire an ECC? Would that not cover the environmental impact? And precisely, that's what the ECC is, the environmental impact of such a project. How would you handle it? Halimbawa, nagka-propose that there is going to be a tunnel dug for 3 kilometers under a certain area. And of course, I'm sure, because like in any other project, there will be required the ECC. How will the DNR handle that determination as to what the environmental impact is? What is the procedure, internal procedure in DNR?
yes, sir. Since we're talking of government projects, these projects are for the benefit of the public. So we give priority to these kinds of projects. And whatever environmental impacts are brought about by the project, it is already being addressed to the ECC, wherein
Yes, but how do you address it? In other words, when a proposal is there is a proposed project, and the proponent gives you the project description, and they ask you for an ECC, how do you handle? Well, I think we're all familiar how you handle normal ground level projects, but the subterranean ones are something is relatively new feature. How would is the other internal rules on how it is processed, this request for an ECC application for an ECC?
Your Honor, I'm not an expert on environmental laws because I'm representing the Land Management Bureau.
Oh.
So I think the DNR representative who could comment on that is the EMD.
Could you, well, we will be in touch with the DNR. Maybe you can tell us also who is the proper section in your organization to,
Yes, sir. The proper officer to handle that is the Environmental Management Bureau.
very well. Then we will be asking for their insights on the point raised by Attorney Sandoval. Is that all? Is there anything you'd like to add?
Yes, Your Honor, is still on Section 3 of both bills. We also made our comment last time that we were proposing that on top of the financial assistance to be given to the landowner, bigyan din siya nung damages on the improvements na. So we proposed that.
But that's in 2447.
No.
Yeah, it has it.
Your Honor, sa CA 141 po kasi Section 112, what that law contemplates is that yung damages that will be incurred by the landowner due to the implementation of the government project, i-reimburse siya doon. For example, if the road traverses his house or yung mga crops niya, plantations niya, the CA 141 Section 112 says that he will be reimbursed for the damages on the improvements. But on the Senate bills, it is silent whether on top of the financial assistance, yun po bang financial assistance, yun na po ba yung damages or separate pa po? Kasi as we interpret it, this bill will not amend Section 112. Parang in-strengthen lang niya yung Section 112. So we propose na i-add pa rin yung damages to the improvements.
Mr. Chairman. Mr. Chairman.
Yes, Senator Gingon.
What do you mean by damages? In the concept of torts?
So yung ano po,
You're talking about damages in the legal sense, torts and damages?
No, Your Honor.
Okay. So what
Yung
do you mean by
actual na cost nung mga crops niya or bahay niya na na-disturb, parang disturbance compensation, something like that.
Well, it's also stated here sa Section 5, no? Replacement cost of structures and improvements. Structures and improvements. I suppose
Okay.
crops
Okay po, Your Honor.
That is
can
one
fall
of the
under
main-
improvements.
One of the main features of the of 244. Ladies and gentlemen, please come prepared to these hearings because we cannot make progress kung hindi nyo pa nababasa. We will ask your comments on these bills, and if you haven't read them, then we cannot get those comments, and that is the entire purpose of a hearing. Okay, so that's clarified. You've cleared that up. Okay. Next on the list, from the NEDA, Engineer Dorado.
Sir, good morning, Honorable Senator.
Yes.
Actually, we have already submitted our comments on Senate Bills 2145 and 2180.
Yes.
Then we are still looking on 2447, but in general, I think there are certain features that needs to be combined between 2447 and 2145. Specifically on the item B, I think this is
Item
5
of which version?
2447. Mr. Chair.
2447, yes?
Yeah, I think this is a good proposal. In case the owner cannot be found, unknown, or
Yes.
deceased, and there should be a deposit. I think this will resolve some of the current issues that the some agencies are facing right now in acquiring right of way. Then I just want to clarify, Mr. Chair, on item C. In case,
Item C from
yeah, also on 2447.
which section?
Section 5 again,
All
Mr.
right.
Chair. As well as with the other bills. In cases between, there is a declaration between the municipal assessor or city assessor and the BIR on the valuation of land, which one will govern? On both instances, no. And then on then on PPP, Mr. Chair, this is also present in other sections of the bill. We were suggesting that the for ROW, in cases of payment by government, it should only be applied in cases of solicited proposal, but not for unsolicited proposal. Because for solicited proposal, the government is allowed to provide subsidy, but for unsolicited proposal, the government is not allowed to provide for subsidy. Then on 5A, item I2, section, this is Bill 2447, Mr. Chair. On item 5A, II.
Let me go back to the point about this is unsolicited and solicited proposals. These are, we are assuming that the projects that are being proposed that will require right-of-way have already been accepted by as a BOT or a PPP project. Therefore, unsolicited or otherwise, you have subsidy funding for this kind of payment. Is that not correct? We were discussing this at length the other day.
Mr. Chair, thank you. For unsolicited proposals, the existing law, which is Republic Act number 7718, expressly prohibits any form of government guarantee, subsidy, or undertaking to unsolicited proposals. So the right-of-way shall be shouldered by the original proponent in case, or the winning bidder in a Swiss challenge process.
And
We only shoulder.
And it does not differentiate. It does differentiate between solicited and unsolicited, whether or not it is adopted as a BOT under the PPPC.
Yes, Mr. Chair. The main distinction between solicited and unsolicited proposal is who will be the proponent of the project. Where does the proposal came from? If the project proposal was initiated by the government, it is a solicited project. But if the proposal came from the private sector, it can qualify as an unsolicited proposal.
Okay, but tignan nyo nga yan, because if it is adopted as a government project or as a PPP project, then we still would need to have the streamlined process that's being proposed by all these bills to be implemented, because although it is an unsolicited proposal, kung tinanggap na ng PPP as a BOT project, then that means that it has been determined by the PPP, Department of Finance, NEDA, that it is a necessary project and it will be favorable. So tingnan nga natin, maybe that is something that we can, because we are putting them into separate classifications when in fact it has been determined by government that they are both, either whether or not they're unsolicited or solicited, that they are necessary and that they're desirable.
For solicited proposals, it is recognized that those projects are the priority projects of the government, and we should give importance to or priority to this over unsolicited proposals. That's why, sir, one of the criteria of unsolicited proposal is that it should not be part of the priority list of the government unless it involves new concept or technology.
Okay. Well, if that is that is the procedure that is being followed. Very well. Back to you, Engineer Dorado. Is there anything else you would like to?
Yes,
bring
Mr. Chair, again on the payment, the initial payment. This again appears in almost of all of the bills. We were suggesting that the intent is actually to pay 50% initially, but we were thinking that we can probably raise it to a higher level to entice the owner to sell their land or to give it to the government. Mainly because at that point, there is already a deed of absolute sale. We commented it earlier also during the House deliberation. So maybe the bill can be checked on whether it can grant a higher amount of initial payment. Again, because there is already a deed of absolute sale by that time.
The proposal now is execution of deed absolute sale. In the implementing agency shall pay 50% of the negotiated price and 70% of the negotiated price of the affected structures, improvements, crops, trees, and the land. So you are proposing what would be, what you have a figure in mind, above 50%? At saka hindi, you have no comment on the 70% for the affected structures. Wala naman, yun sa 50% lang.
Yes, sir.
Pwedeng dagdagan. So, i-front load natin ng konti yung pagbayad.
Wala, Your Honor.
Well, I think it will really depend on the funding, if we crunch some numbers to see what kind of funding requirement that will be. We are familiar with the 50%. But, okay, that point is well taken. Yeah.
The last comment, Your Honor, is on the on Section 5 of 2447, Item A, double I, the replacement structure. Yeah, I think maybe we can clarify in the IRR, because this is the situation I understand on the ground. When you expand a road, certain piece of land are acquired, no? When you expand a road. So, posibleng mangyari, sir, there is an old house, and you will demolish a part of that house, and how are you going to pay him?
Determine the valuation.
Yes. Then secondly, so old house siya, dinimolish mo yung, sabihin natin, one half. So are you going to pay him the old house, no? That is the reality on the ground. And I think some of the owners would say that okay lang yan, you demolish my old house, my entire old house, you put it at the back, may natitira pa akong lupa. I think that is one of the issues that has been raised. Kasi ang claim nila, pag pinutol daw yung bahay nila, like for example, sala yon or something like that.
May katwiran naman. Pagka sinira mo na lahat ng bedroom, hindi na bahay yun, di ba? So the replacement cost, how to determine that replacement cost?
Yes, sir.
I think also the nuance on that is that will you determine the replacement cost only of the part that you are demolishing, or with the recognition that it's no longer usable, the entire structure? Interesting point, actually.
Mr. Chairman,
Yes, Attorney Foronda, sa Public Works.
Ang procedure niyan, Mr. Chairman, is if yung remaining portion of the house is no longer livable or structural stability is hindi na pwede, babayaran na rin namin.
Pero yung valuation, paano ginagawa?
Yung
Buo na.
Yung buo na.
So lahat kahit anong but is that that's the case, is that how it's done in every case? Kung may may structure, may partial demolition, is it always the entire structure, the valuation of the entire structure?
Not necessarily, Mr. Chairman.
Not necessarily?
Case-to-case basis lang, Mr. Chairman.
Mr. Madrasto, baka you would like to jump in on this.
Thank you, Mr. Chairman. Basically, what we have seen all throughout is that the Department of Public Works always checks whether what is the remaining is still something that be considered as is still a home. for them,
Yeah.
or something that their factory can still use. If not, then what they normally do is they value the whole and pay off the replacement value. So, like for example, sometimes, kasi ang nasa harapan ho natin ng lahat ng bahay is where you have the carport and you have your sala. And sometimes, kung may second floor, nandun yung bedroom. Pag natapyas po yun, wala na talagang pupuntahan eh. Kahit kalahati po yun, so ang tendency nila, binabayaran na lang yung buo. So that means pati yung...
So you're speaking historically.
Yes,
this is what has
historically.
been- this is
Kasi
what
po ang nangyayari, kapag hindi naman ho nila ginawa, nandun ho yung resistance to let go. Tatagal ho yung negotiations. Then the other one, I was appreciative of what Engineer Dorado, Director Dorado of ENEDA has mentioned, which is yung amount to be put up. Kasi po, we have noticed that a lot of homeowners or lot owners, they are fearful if they will still get paid of the balance. Doon na sila natatakot eh. So even if there is a 50%, ang worry nila, paano kung iba ng presidente, babayaran pa ba yung diferensya? Yun ang takot po nila eh. And, you know, it's understandable for them eh.
Of course.
No? So, that's why I appreciate the whole concept of probably increasing it. Anyway, naka-escrow naman po
Well,
yun eh.
since you are you are deeply involved in this, what would be a good number in to instill that confidence that in the landowner that in fact they will be paid to the full?
Well, in the first place,
Kasi
the,
sa structures nasa
the money is in
70% na
deposit.
tayo.
The money is in deposit as escrow. So, as far as the government is concerned, kanila pa rin naman yun. Hawak pa rin ng gobyerno. So, if the appropriations is made for the entire amount, then it can be already put in escrow. So that the owner already knows he's finally getting paid. So, he's sure of getting paid. So, it's easier for him to agree to sign off. Kasi ang nangyayari po,
So, but your thinking is not to increase the 50% upon.
It's to put it up already 100% on escrow, not to pay them immediately. It's the balance should be an escrow, so they're assured that they have the money, that the money is there.
The money is available. Bakit pa i-escrow?
Why escrow?
Kasi po may mga documents pang kailangan matapos yung lot owner bago mabayaran ang buo eh. But assurance lang na pagka nabuo niya yung mga dokumento, mababayaran siya.
So your idea is not no longer to increase the payment
But
upfront
may
payment.
deposit ng the balance is already on
So
deposit.
pay the 50%.
Yes.
And put the 50%
On escrow.
in escrow until
Yeah.
the completion of
Yes,
all of the requirements.
yes.
That's an idea. Yeah. All right.
Mr. Chair.
Maganda.
That would work. At saka hindi, if the purpose is to give confidence to the landowner that he will in fact get paid, makikita niya, it's in escrow, pero hindi pa niya hawak, pero nandyan na yung pera. He just has to, he or she has to complete the requirements.
Kalimitan naman po kasi yung mga eredero ang naiiwan eh.
Yeah.
So yung mga eredero, doon nagkakaroon ng conflict kung pipirma lahat dahil ang feeling nila, hindi naman bakit ako pipirma. Yun ang pumukan. Ngayon, kung alam nilang there are funds already available, all of them will suddenly sign.
No, but that's the point of Engineer Dorado is that yun na nga na kailangan instill some confidence. That's why his proposal to increase. But although I think the escrow is probably, would you, Engineer Dorado, what do you think about the alternative proposal of putting the funds already, the remaining payment already in escrow? That will fulfill your objective of encouraging the landowner or landowners to proceed and complete the requirements so they get full payment. Ganun na rin.
Your Honor, I agree with the suggestion of Director Lito Madrasto.
You
I
should
think that will settle the issue on doubt on whether they will be get paid or not.
Yeah, and that was the point that you were bringing up. All right.
Mr. Chairman.
Yes,
may I
Attorney
add in?
Foronda.
I think there is no more need for an escrow because in every, right now, in every ongoing projects of the government, nakaalat na sa project cost yung payment of right-of-way. Kasama na yan 100%. And sa bagong batas na ipinopose ni Senator Gingguna, nakalagay na doon yung pag-ako ng gobyerno ng magbayad ng capital gains tax. That is to induce landowners to negotiate, to enter into negotiated sale, Mr. Chairman. So I think there is no more need to escrow the 50% of the amount of the.
Mr. Chairman.
Yes, who would like to speak? Attorney Romero?
Yes,
or-
Mr. Chairman,
Yes.
good morning. We agree with Attorney Foronda. In fact, if the goal is to remove the roadblocks for the whole process, it might sound easy on paper, but for the government to set up an escrow account for all the lots subject of negotiated purchase, it might be procedurally more difficult than it sounds. At present, the procedure is the lot owner can only be paid after titling in the name of the government, and that's somewhat burdensome on the landowner. So with 50% for the lot and 70% for the improvements, we think it's already fair. The balance to be released to the lot owner upon titling or annotation as appropriate is actually an incentive for the landowner to cooperate with the government for the submission of documentation that are necessary in titling. In a lot of cases we handle in the OSG, Mr. Chairman, after the landowner has been paid, they tend to be relaxed in complying with the documentation that is required to actually transfer the property in the name of the Republic of the Philippines. So, agreeing with the DPWH, Mr. Chairman, perhaps as the funds are already earmarked for this project, there should be no doubt on the part of the landowner that he will receive the balance provided he submits the documentation.
Yeah, but as you yourself said, that this is a problem, that the people do not complete the requirements, despite the fact that you already have paid 50%. And yun na nga, this is the problem we are trying to address. So,
if I may,
what we are trying to find is a method to at least alleviate to some extent the problems, as you have just stated. To do nothing is to put us back in the same situation that we are in now.
Yeah, Mr. Chairman, to clarify, at present, and the DPWH may correct me if I am inaccurate, the landowner in a negotiated sale can only be paid, this is at present, Mr. Chairman, once the property is titled in the Republic of the Philippines. Meaning, they execute a deed of sale, nothing, they don't get anything. They will have to wait for the processing of the real property tax clearances, the transfer taxes with the LGUs, the clearance from the BIR of the payment of the capital gains tax, and the ultimate titling of the property in the name of the government before they can receive payment. So with the proposal under 2447, wherein they will already get 50% upon execution of the deed of sale, we think that's already a big step, Mr. Chairman. And the balance will be their, incentive to cooperate with the documentation for titling, among others, Mr. Chairman. Mr. Chair.
I suppose it will achieve that same escrow effect, because if it can be shown, it's included already in the cost of the project cost in the. And it has been appropriated and it is sitting in some account somewhere. I mean, I take the
Yes.
point that setting up escrow accounts for each
Mr.
and every
Chairman,
single one.
in our experience, those who don't get paid are those who have yet to comply with all the documentary requirements.
That's right, but we want them to comply.
Correct,
and we want,
correct, Mr.
and
Chairman.
That's why this has been included.
Yes, Mr. Chairman.
Let's ask the author. Yung 50% payment. That was my understanding is that was included exactly
Yes, Mr. Chairman.
to be an incentive.
Yes, Mr. Chairman, as an incentive.
Except that the NEDA thinks that the incentive should be maybe more. Pero baka the implementation might be complicated. Okay, well this will, I guess we're down to the numbers.
But no, Mr. Chairman, knowing how government works, setting up escrow accounts might be time-consuming.
Mr. Chair,
Yes, Attorney Mejia.
just a suggestion, Mr. Chair. I agree with, of course, OSG, and I agree with Mr. Madrasto and, of course, NEDA. Instead of an escrow, it's very difficult. Why not a certificate of deposit? Meaning, government deposits the money, but they will not release the balance of 50%, but they will show the landowner that there's already an existing deposit in the land bank or any government depository. It's actually simpler. It does not have the administrative requirements of an escrow and the financial fees, but it of course gives the necessary confidence for the landowner that they will be paid. So I think that much, and the money is still with the DPWH.
Who pays the escrow fees?
Then whoever
Pag
sets up
deposit,
the
sir, kasi
account.
walang.
Yeah.
Mr. Chairman, I just like to say that dun sa escrows, no, put it into record, who pays for the escrow fees also? Mag-aaway na yung landowner at saka the government agency niya.
Yeah, whoever, well, I'd say presumably whoever opens the account. But anyway, if it can be shown that those payments have been appropriated and can be considered by the landowner as a receivable upon completion, then that's already bankable because that's a receivable from government.
Mr. Chairman, I believe that the goal is to sweeten the pot for the landowner.
Something like that. Yeah.
With the burden of capital gains tax falling on government under the bill of Senator Gingona, that's already a big incentive because that's a major stumbling point in our experience. The down payment of 50% for the land upon execution of deed of sale is another big incentive. So perhaps the goal, it is my suggestion, Your Honor, that maybe if need be, you can increase the percentage of the down payment, but to make it further palatable for the landowner. But other than that, the certificate of deposit may also be undertaken because it's a simple procedure. But to undertake the escrow,
Para may hawak ano.
it's really a certificate of funds that are already allocated in the first place. If it will help them boost their confidence, perhaps. But that's something for the committee to consider, Your Honor.
Thank you, Attorney Romero. That's an interesting point. Attorney Dirain, you want to add something?
Sir, as a matter of procedure, po, sa DOTC po, we pay 70%, then we retain the 30% para kung sakaling hindi nila i-transfer yung title, it should be, the 30% will be answerable for the payment of taxes, sir.
If I may, Your Honor,
Yes, go ahead.
in the current draft of the bill, the taxes will be shouldered already by the government.
By the government.
So I think the balance is really the incentive for them to complete the documentation needed on their
To
part.
fully comply.
Yes, Mr. Chairman.
All right. Well, anyway, we will see if that number needs to be amended. Ikaw, Eugene, we'll work on it when we go to the working group. All right. Is there anybody else who wants to weigh in on this particular subject? Attorney Mejia.
I would like to proceed to actually make my comments on the other provisions. But
Well, yeah, okay, if you want.
no. But we're good.
Actually, next
Yes,
up
sir.
will be HUDC. Kasi yung relocation is can we hear from HUDC at who will speak? Mr. Teves?
Good morning, Your Honor.
Yes.
Well, most of our comments during the previous consultations were already incorporated in Bills 2145 and 2447. Well, as regards to Section 9, letter B, it was already stated that costs on development of resettlement projects, including planning, social preparation, and other activities, shall be covered for funding. We would just like to get clarified if the conveyance of these funds shall be transferred or conveyed to the NHA ahead of time, since social preparation activities, medyo mahabang proseso po kasi. So sana po ay mailagay lang yun, yung conveyance ng funds to the appropriate implementing housing agency. And then we would also like to get clarified if under a PPP concept, would it be possible if the project proponent can advance the cost of development of resettlement sites? Hindi po kasi nakalagay rito eh.
It is possible.
It is,
My
sir,
underst-
given the...
well, okay, let's
yes.
Attorney Austria.
Sir, given the limitations of the existing law, which is RA 8974, it is now a practice by the implementing agencies to request the project proponent to advance the cost of the right-of-way in order to avoid future delays in the construction of the project.
Well, in which,
Subject to reimbursements or by
then it will not
implementing
be, since that is already the practice, then we can, there's no harm, there's no harm in including or clarifying that point in the law.
So far naman wala po nagrereklamong private sector. In fact, the private sector is very helpful kasi alam nila na magkakaroon din ng implications sa kanila kung magkakaroon ng delays dun sa right of way.
Okay. All right. What else?
Yes, sir. Yun lang po naman. Gusto lang namin mag-appear yun sa proposed bill.
Your
Honor, if I may.
I don't think there's any
Your Honor.
to include that. Yes.
Just a comment.
Yeah. Attorney Maya.
As regards, because the TRB is, of course, always in joint venture with the private proponents, I think the cost of relocation becomes too big, Your Honor. Like, for example, for one of the projects in the north, the cost of relocation is 1.4 billion pesos, and the project cost is only 2 billion. So it's very difficult for the project proponent to actually advance cost that is almost equivalent to its project cost. So that's something that, while I agree with PPP Center that it has been a practice, but the relocation cost, Mr. Chair, it's not significant. But we should not make it as a general rule, especially since, let us make that the advance of the project private proponent as an exception that probably be done through a memorandum of understanding or a memorandum of agreement.
It could be one of the options, not an exception.
So I guess it's an option if that's the case. Hindi kaya ng proponent yung napakalaking relocation, then they will have to resort to to waiting for the government to provide the funding for the. I think that is just also to make the possibility if the project proponent is willing. Kasi i-refund din naman sa proponent eventually. Pero para mabilis ang takbo, they can. They don't necessarily have to. Yeah. So that it's not mandatory. I remember we discussed this also. Or rather may, not can, may. Tama. So, all right. So, Mr. Teves, is there anything else that you'd like?
That's all, sir.
That's all. Thank you. Do you have a position paper specific to 2447? Because we have already several comments from the OSG.
Good morning, Your Honor. With respect to SB 2447, we have not filed a position paper, considering that it was referred to the undersigned only last Friday. But we have already reviewed we are in the process of reviewing SB number 2447, and we have some observations, and I would like to I move that my colleague, State Solicitor Romero, would further elaborate on the matter.
Okay, Attorney Romero.
Yes, Mr. Chairman. Firstly, we'd like to thank the committee for inviting the OSG. It seems that we were not invited in the previous hearings, Your Honor. And as the frontliner, one of the frontliner agencies in expropriation of the government, we appreciate being present. Your Honor, we are happy with and fully support the bills as presented because they introduce measures that would significantly remove those roadblocks that we are trying to eliminate. A significant feature under 2447, Your Honor, and as with the other bills, is that the moment the government pays for the lot in expropriation cases for the lot, the zonal value of the lot, and the replacement cost, it becomes the duty of the court to automatically issue a writ of possession. Okay? For the government, that's good because a lot of our hearings are delayed because at present, before the writ of possession is issued, the landowners have to establish their ownership, their right to title, the settlement of the estate of the deceased landowner, among others. So it's a really long process. And the government is somewhat taken hostage by the landowners who refuse to submit such documentation. So it is a very good measure if upon payment by the government of the zonal value of the lot and the replacement cost of the improvements, if any, if the payment has been deposited with the court, it becomes the duty of the court to issue the writ of possession, after which the government can already move in and start construction on the lot. It's also noted that the capital gains tax becomes the burden of the government if the case is one of negotiated sale. This is very welcome also because it makes the option to sell voluntarily to the government more attractive to the landowner, and it serves as a disincentive to have to resort to expro. So if you resist the offer of government, then you have the burden of paying the capital gains tax. This is also a good move because if we can avoid litigation, if we can avoid the filing the expro case, then it would also be good for the whole project in general. The provisions on the ban on developments in the right-of-way area is also welcome because in practice, once the project is announced, in some cases, suddenly there's a new house. There's a new house down the road, and the government has to pay for that house that wasn't there before. Correct, Mr. Chairman. And then further, just one observation, Mr. Chairman. While we welcome the proposed provision on the automatic issuance of the writ of possession, once the funds are deposited, this takes away from the landowner the opportunity to question the propriety of the taking, the public purpose, which is previously or presently granted to them under the present law. Right now, if the landowner feels that the road need not pass through my lot, he has that option. He can question that before the court and challenge the issuance of the writ of possession at present. So, but with the way it is set up under the bill, there seems to be no more opportunity unless, although it does not prevent the landowner from filing a case to, filing a motion to defer issuance of writ of possession. But since the issuance of the writ of possession is automatic, and the court has a duty to issue it, even ex parte, although I'm happy that it's automatic, the landowner is might be placed at a disadvantage if they were to question the propriety of the project.
Mr. Chair, if I may make a comment.
Yes.
Yeah, actually, I'm also familiar. I used to work with the Office of the Solicitor General. I don't. While I agree with Solicitor Romero, actually, it does not preclude the owner from this law. No, does not preclude the owner from questioning the propriety. Because in fact, there's a first stage. In fact, the issuance of a writ of possession is only an ancillary remedy. No, the question under Rule 67, to question the propriety is the first stage actually of the expropriation proceedings. At any time, under the present law, at any time, even at the filing of the complaint, at any time, the government may actually ask for the issuance of a writ of possession. So what will happen, no? In fact, if there's a writ of possession and the government, the court finds that the taking of government is not proper, damages will be paid by government equivalent to the BIR zonal value deposited. That's the present state of the rule. In fact, this is what we are actually doing right now. No? Even in this law, it does not. This law does not attempt, or at least how I read it, 4667 and the other bills. No? Does not attempt to amend Rule 67. In fact, it seems to veer away from really parang clashing with the other branch of government. So while I agree that it seems that the government, I mean the landowner cannot question the issuance of writ of possession because it's automatic, in fact, it will benefit them. If indeed the taking of government is improper, damages will be paid equivalent to the BIR zonal value deposited by government. So I think this does not change actually the state of the law right now, state of the procedures, particularly Rule 67, Your Honor.
Honorable Chair,
Attorney Diaz.
yeah, maybe perhaps it would be, maybe perhaps we could, the comments or the suggestions of the Supreme Court may be needed, considering that they have they do, or they are constitutionally given the power to promulgate rules and practice regarding court procedures. While this representation sees the point of Attorney Aris, I agree on the other hand with the position of Attorney Romero, in that the trial court judges might have confusion with respect to, on one hand, this Senate bill, should it become law, and Rule 67, Your Honor.
Let's just because again, let's keep our eye on the objective here, which is really to make the process more to quicken or streamline the process. In your collective experience, how does this problem crop up? Does everybody file? Every landowner at some point file to suspend or defer or question the taking of the properties, and to defer in the issuance of the writ of possession?
In our experience, Mr. Chairman, I think I've only heard of one case in the hundreds or thousands of cases wherein the landowner questioned the propriety of the taking.
So we have a solution looking for a problem then. Kung isa lang naman ang then I don't think that is I don't think that is a problem. If, as you say, it is a one instance in I would imagine thousands.
Yes, Mr. Chairman.
Sige. So then that is indicative of how it actually operates on the ground. All right, I think yes, Mr. Masdastro.
I'd like to comment on the same thing. we in the private sector, what we've noticed is that normally some judges will take their time in issuing the writ of possession. Our discussion with the Supreme Court is because the rules indicate that there is no specific time that they have to release it. And as such, it has become a window for negotiation. And our feeling is that the writ of possession has become a negotiable instrument. And that is why we've been asking the Supreme Court to come up with a definite date, how many days, to have that issued out if all the requirements are already fulfilled. And in fact, they were talking to us already about 15 days as a maximum, 15 calendar days. We said we can even make it 15 working days because, of course, they have to check whether everything is complete. But what is happening is that there are situations where, like for example, EDSA could not be extended all the way to the bay. It took us how many decades waiting for just one writ of possession when everything at the back was already complete. Imagine that. And, it hampers the development. And to me, the automatic is already okay. I don't see anything wrong because, true, I've never seen a landowner that has been so recalcitrant in trying to block. Very, very few. And the most, what do you call this? Blatant is the one on EDSA. Blatant is the one on EDSA that stopped the development for so long. And we should not allow that to happen again. And I appreciate the concept of having that automatic thing. Good.
Well, that's coming from, especially from the executive director of the PCA. That is, I think, from the private sector, saying, understanding that this is the problem, and again that the problem of landowners contesting the taking of the land and then contending that it is improper seems to be a exception rather than the rule. But anyway, the point is well taken, and perhaps the compromise that the PCA is working out in terms of how many days that they can will probably address that problem. All right. Thank you. So we now continuing to go down the list. I'd like to hear now from the COA. Who would like to? Miss Lasso, or Mr. Rosales will speak for COA. Mr. Rosales, please.
Sir, we fully support the Senate bill. It will spearhead the common problem in the implementation of projects, particularly on the part of DPWH. It has been a perennial problem by the department, and it has been a subject of an audit observation which are contained in the consolidated annual audit observation which is concerned particularly on the delayed implementation. The Senate bills will shorten the process of project implementation, particularly by providing timelines in the general guidelines on expropriation, which has been the problem of the DPWH.
Very well. So that is the position taken by COA. That
the position of the COA insofar as the DPWH, the COA insofar as.
Thank you, Mr. Rosales. Now the BIR, Attorney Nina, you can. Okay. Thank you, Mr. Rosales. Now the BIR.
First of all, we do not oppose the implementing agencies shall be liable for the Internal Revenue Tax fee and tax, as this is revenue neutral provision. It will become an exception to the rules set in the National Internal Revenue Code as to already the samples, Your Honor. This is to distinguish property, the properties that are involved, whether they are capital or ordinary asset, as this is treated differently in the NIRC. So that is our comment for Senate Bills 2180, 2145, and 2447. On 2447, on the 30-day limit, we agree with this, as this would expedite the decision-making, whether it would be a negotiated sale or an already contained. Lastly, on sections 5C of Senate Bill 2447 and E of 2145, may we request that we be given time to comment on the provision where the zonal value is more than 3 years. The BIR is to set to formulate the zonal value time to provide the committee the actual procedures on how we set our zonal values.
But what is your comment on the 60 days? Because that is you.
I would have to study, sir. We just saw this provision, sorry. But we would like to be given time to check first if the 60 days is enough or if it should be lengthened. But basically, Your Honors, at present, most of our regional directors are undergoing an updating of their zonal valuations. So basically, we might be able to meet the 3 year period for the zonal valuations used here. But as to the formulation of the zonal values, we would like to be given time to present to the committee the appropriate length, perhaps.
Okay, so
Thank you,
that
Your
will still be dependent on the studies on your procedures in that regard. Okay, thank you, Attorney Asuncion. From the PPPC, we've already heard from, but maybe you can give us an overview, Attorney Geronimo Anzares. You, Attorney Austria, will be the one. Okay, sorry.
Thank
Attorney
you, Mr.
Austria,
Chair.
please,
The PPP Center strongly advocates and supports the passage of the Amendment to Republic Act 8974, since the program is one of the most affected by the delays incurred in the delivery of the right-of-way. So this one is very timely, sir. And we would like to thank the Senate for recognizing that fact and for taking the initiative to pass this into law. But sir, we have some observations on Section 9, specifically related
Section 9.
Yes, sir, of Senate Bill numbers 2145 and 2447. Last paragraph. The provision related to PPP.
Yes.
Sir, under this paragraph, it provided two options for projects for PPP projects. The first one would be the implementing agency may require the project proponent to advance the funds covering the right-of-way, which shall be later on reimbursed by the implementing agency, or the proponent finance the right-of-way, but to be fully or partly recovered from the user fees. So it will have a huge impact on the affordability of the user fees. If you may recall, sir, in our last hearing on the BOT law amendment, it is a major concern of Senator Recto to protect the consumers or end users of the PPP projects. There are other sources of revenues that would enable the private proponent to recover its cost. It should not be only based on the user fees. There are other commercial revenues available to a certain PPP project. So pwede po doon kunin, not only on the user fees.
Tama, it would run counter to what we were trying to achieve in the BOT amendments to the BOT law, no? Because for the information of the others, the question we are also in the middle of amending the BOT law, and this came up because in the case of the MRT, there was a large subsidy paid to the government, and yet the prices of the price of to the users, the cost to the users, increased. And the question was raised: why was not the subsidy applied to the cost to the users? In other words, to be used to maintain the cost, to at least maintain or even lower, ideally, the cost to users. This would allow the exact opposite to happen. It would allow because they will finance the right-of-way cost, tataasan, they will pass on the cost to the user.
Sir, yes.
So there is that possibility.
Yes, Mr. Chair. For instance, in a toll road project, the private proponent can recover its investment costs not only on the toll fees. There are also commercial revenues associated with the project, like putting up a commercial establishment, gasoline stations, and other retail stores within the facility.
So we remove entirely B. Would that be your proposal?
Actually, sir, yes. Sir.
Yeah. B.
Sir,
Para
yes.
lang hindi, so that there is no option for the proponent to pass on the costs of right-of-way costs to the the users of that facility or that infrastructure.
Yes, Mr. Chair.
Yeah.
And also, since Section 9 pertains only to national government infra projects, Section 9...
Say, or remove, first of all, or specifically mention the other sources of revenue for the proponent, and specify that the right-of-way costs be taken from that and not be a cost that will be passed on to the user. Or to remove B entirely.
If we will
Yes,
delete...
Mr. Madrasto, you were
Yeah.
with us in that discussion.
Because what is prepared here on the section is that it is which shall be recovered partly or fully. Because there is a situation wherein there are not enough other areas that they can recover. So if you're going to take it away, then you are left only with the reimbursable from government. My point is, it's just like your connector. It's a viaduct. So their source of income will only be the toll. And yet, if you are going to ask them to finance the right of way in Manila, and government does not have the money to reimburse them, how are you going to get the project through?
One way of writing, if I may, Mr. Chair, one way of writing, I think it's a matter of style, is just not to single out user fees as a source of the recovery cost. We can put a caveat, a general clause, or such other revenues arising from the project.
Don't take it out totally. Because my idea here is that you simply expand how they're going to recover it. So it's not totally only on tolls, fees, or tariffs. Rather than take everything out, you include other sources of revenue, Mr. Chair. Rather than just take it all out and government is left with only to ask them to finance and then reimburse totally. at least you expand how they can recover if they need to
But
recover.
as it is written, the finance right-of-way cost, it is all tolls, fees, and tariffs. It does not speak on other sources of revenue.
That's the point, Mr. Chair.
Oh.
Probably what is needed is to simply expand this on other sources of revenue by the proponent to recover. So it's not necessarily only
But
on
you
tolls
would not
fees.
agree that tolls, fees, and tariffs should be removed as a source of funding for, because again, what we are worried about is passing on the base cost to the user. So to avoid that, we can remove the option for the proponent to increase. Pero hindi, gagamitin din niya yun eh. Even if they don't increase, they will still use they will still use those funds to pay for the right of way. No? Does that mean necessarily that they will increase the user cost? So we'll just perhaps we can study this further, and so that we can make it clear that it cannot those fees cannot be funded. The right-of-way cost cannot be funded by an increase. Ganun na lang, di ba? Cannot be funded so that at least we keep the user's cost to the same level. They cannot be funded by an increase. Because if we take away tolls, kukunin them, gagamitin talaga nila yung collection nila eh. They have to use that fund. Yeah, for cost, you cannot remove that as a source of funds. What we are targeting is not the actual, but the increase. We want to preclude that from the options of the siguro that's yeah.
Agreed, Mr. Chairman, because in the section B, the financing of that right of way becomes part of their cost.
Yes.
And how are they going to recover their entire cost, including that right of way, which is their fees?
Yeah.
Now, an increase is something else.
Yes,
that
correct,
I agree.
Yeah.
And in fact, even on adjustments, it cannot be utilized.
Perhaps in the amended language, we'll talk about an increase and say that they cannot increase to pay those costs, to pay the right-of-way costs. I think it's because it's the increase that we are concerned about, not so much that they are collecting tolls, fees, and tariffs. All right. Okay. Is there anything else, Attorney?
Since Section 9 speaks of national government infra projects, may we also propose that the provision related to PPP be applied also to local PPP projects?
Local PPP projects?
Section 9, dun sa
Yes.
title, sir, it says appropriations
Yes.
for acquisitions of right-of-way, site or location for national government infra projects in advance of project implementation.
I see. Okay.
Just to make these options also available to local PPP
I don't see
projects.
any difference actually in the sense national and local. That will also make it easier for the locals, the smaller. Yeah, the same problem that we were talking about. Okay, that's noted and point is taken. Anything else?
Lastly, on Section 10,
10.
since we have a subway rail project in our pipeline, we welcome the provisions under Section 10 of Senate Bill number 2447, wherein the government wherein it is being proposed that the government should not be prevented from entering into a private property for subterranean or subsurface works.
Is 15 meters the right measurement?
Mr. Chair,
Because
can I comment on that?
depending on what are the proposals that you have in front of you. Yes.
Actually, sir, for that project, we have...
Yeah, just have a look at it because that's a
Yes,
technical
sir.
question. Yeah, we will need exactly. The senator is correct. We will need to ask the engineers if that is the correct number. Because if it's not, then we'll have to change it so that it will apply, especially in view of the projects that you are already assessing now. in the PPP center. Yes, Mr. Madrasto.
I'd like to comment regarding the depth. In determining the depth, one must consider the vibration that will be impacting the surface. And I feel that 15 meters is too shallow. Too shallow. Outside of the country, what we have done has always been below 50 meters.
It says, if such entry is made more than 15 meters.
The
So
problem, Mr.
it's-
Chair, is
it-
that consultants might suddenly come up with a design only at below 15 meters. Then it's only more than 15 meters,
As a
and not
technical-
considering the vibration upstairs. Because that, if the vibration is not considered, especially there are movements underground, then naturally everybody on top are going to get angry. It's going to be a huge political problem for everyone. So I think we have to ask the DNR, especially those in the Bureau of Mines. They know very well what is that depth that will not have much impact, negative impact on the surface.
It will, of course, depend on what is the tunnel used for. Kung heavy equipment ba ang dadaan dyan, or will just be the light railway system, or what depends on what it's going to be used for. So okay, so we'll get some technical input from the DNR. Tama, Bureau of Mines will probably have a better idea of this because they run into this problem every day. Okay.
Plus the structural engineering.
Yes, just that will. I think is it only the depth at which the structural integrity of all the structures above are not affected, or is there also what you were mentioning, the vibration in terms of the complaints that we will get from all the
Yes.
buildings that we are tunneling
Yes.
under? So again, I think Bureau of Mines will be able to give us a good idea.
Especially, Mr. Chairman, that in Metro Manila, we already have a lot of high rises with 6 levels of basement underneath. And therefore, the foundation is even deeper than 6 levels. So we have, I think this has to be considered so that the entryway shall not impinge on those.
Your Honor. Yes, Your Honor, we agree with Mr. Madrasto because that was what we were saying a while ago, Your Honor, because the vibration might be an infringement on the full enjoyment of the property owners of their property.
Chair, that has been the problem in some of the projects in fact in Tokyo. And as such, they had to close down some tunnels and go deeper because of that. It is the negative vibration on the surface.
It has happened, I think, in many of the cities.
Yes.
I know for a fact in London, the same thing had to happen. They had to close tunnels because, whereas it was all right before, now nalagyan na ng malalaking building, so they had to close them down and dig deeper. Okay, so again, with the technical input from the DNR and their appropriate subsidiary agencies would be needed. Okay, PPPC is...
That's all, Mr. Chair, but we request the indulgence of the committee to allow us to submit our official position paper
All
on
right.
the
All
three bills.
Attorney Mejia, do you have anything to add to...
Actually, everything has been said, except for the Section 10. So we're actually really, well, my position, my personal position, actually it violates certain property rights. No, in fact, the Supreme Court has already ruled that the owner actually owns up to 100 meters below. So actually, I don't know. Maybe probably the government simply pays for the right of way, pay for the land, including the surface and the subsurface. No? So if we do that, probably a project, for example, a tunnel, no? Probably the government can buy the surface, including, of course, the
That is the
subsurface.
latest jurisprudence, is up to 100 meters.
Yes, sir.
Masyado na malalim.
Oh nga po, actually, it's in Mindanao. It's for National Power Corporation. It's an NPC case. Actually, I personally handled that. Actually, we lost that case to OSG. So that's why that's the present jurisprudence right now. It's around 100 meters. It's for a NPC tunnel.
Is that for
an NPC tunnel?
for an what is the NPC tunnel used for?
Actually, it connects the Agus River from Lanao, Agus 1 to Agus 7.
Yeah, of course. Yeah, you did lose that
Of
case.
course, yeah, it's under the ano.
I did not know it was 100 meters was the threshold.
So that's actually a difficulty right now.
We're going
Anyway,
to take that into account now.
Yeah, Attorney Mejia, are you saying that since it's 100 meters, anything within that 100 meters, there must be compensation already?
yes, actually that was the ruling of the court. Hence we paid, NPC paid the landowners of the surface. And the sad thing is because
How do you value the
actually it's as if we paid for the surface, the whole thing, in the value of the surface is equivalent to the value of the subsurface. That's how the Supreme Court ruled. So that's why we've recommended, if we're going to expropriate the subsurface, we might as well expropriate the whole surface and the subsurface.
Might as
so
well
that
do the whole
party can
thing.
actually use of the surface.
Well, you can do it at 101 meters.
Pwede rin.
Ang lalim nun.
Ang lalim na nun.
Chair, may I...
Just as a matter of interest, at what depth then was...
Because it's actually mountainous, it's between actually 50 to 100, no? So the highest point was actually 100 meters. I think the lowest point is around 50.
But the
50
entire tunnel was considered within the 100 meters.
Yes. Yeah.
So valued as such.
Yeah.
Yes, Mr. Madrasto.
I'll get back to the committee, Mr. Chair. We will check with our colleagues in other countries, because I do believe they came up with already their own laws limiting private ownership in the subterranean, so that below that becomes back into public property. I'll just have to check our colleagues in the different areas as to what are their depths that is already in their law. Because we were looking at that.
It depends on the zoning.
Yes.
Because residential, I know in London, the residential, they are allowed to go quite far down. But if it's a commercial, the other problem is that in the more developed cities is that there are many other yung mga water pipes, now fiber optic, cables, telecom, even the old sewage systems that have to be taken into account. So I guess it's really dependent on the area, what it will be used for. So it is it's well, it's a new feature. We don't really have that many. We haven't had that many big-scale tunneling projects. Yes,
No, I just want to ask Attorney Mejia, para mabilis lang yung pag-research. Anong title ng kaso?
I'm not sure, no. Pero it's I'll get it. It's National Power Corporation versus.
Anyway, that's enough. NPC versus somebody.
Yeah, I'll give you
Okay.
that. It's penned by Justice Natura.
Natura. Okay, that's enough. Thank you.
I'll give you later, sir.
Yeah. So we need on the subterranean, on the section on subterranean development, we will need both a legal and a technical assessment on exactly how to handle it. All right. Yes, Attorney Mejia, is there anything else you'd like to
actually
add?
last comment, because under section 4 paragraph B, we seem to be paying the informal sectors actually twice, no? One under this law, we're paying for the replacement cost of his improvements, and the other under RA 7279, because we'll give him, I presume, RA 7279 will apply, so we'll give him relocation, and if he opts not to get relocated, he gets financial assistance. So I'm just clarifying if it's the position of this committee, sir, that we will pay them double. One, the relocation cost.
That seems to be negotiation. No, I don't think that there is an intention for that kind of payment to be made twice. You cited which
Section 4, paragraph B po. Section 4, Mr. Chair.
paragraph B. Ano to? I can't.
Mr. Chairman.
Yes, Senator Gingon.
Yes. Anyway, HUDC is here. Under 7279, has it ever happened that they were paid twice? Importante lang, mabayaran sila, no?
During the implementation of the project and in the absence of a resettlement site, the project proponent or the implementing agency may provide financial assistance. As regards to this Section 4 po kasi may distinction between a property owner and an informal settler families. Kasi pag ikaw yung property owner, yan yung may parang may replacement cost. Whereas if you do not own the land that you occupy, you're an illegal settler there, doon po magfo-fall yung provisions ng UDHA, ng RA 7279, where you have to provide the settlement sites.
So is there an instance where they might be able to claim for compensation twice?
In this setup, sir, it seems, sir, because under Section 4, Section 4B of at least of this proposed Senate Bill 2447, it says here, sir, that may I read, sir? The above provisions pertaining to Section 4A shall also apply to all owners of structures and improvements who do not have legally recognized rights to the land and who meet all the criteria. In fact, the criteria below are the criteria under RA 7279 also, that they are not professional squatters, that they must be a Filipino citizen, that they must not own real property. So in fact, under this Senate bill, they will receive compensation equivalent to the replacement cost of their structures, that's one. And second, under RA 7279, they will receive either relocation cost or if they choose not to get relocated, financial assistance.
Yeah.
So effectively, they are getting two payments for under this law and under 7279, at least for the informal settlers, which I believe may cause some disparity between a formal settler who really paid for their land and for their structures and an informal settler. That's
So
that's only comment.
we should make that that differentiation between formal and informal settlers. I think is the politically correct categorization there. That the compensation schedule will differ.
That's right, sir.
Depending upon which will depending upon how the not landowner but those who are being moved, not necessarily the landowner, but whether they're formal or informal settlers.
But also in some cases kasi, sir, there are informal settlers who are also provided with additional financial assistance aside from the settlement site. So dagdag na lang po yun. Depende po yun sa implementing agency.
But that is already under 7279.
Yung iba po, nagdadagdag pa rin ng mas malaking halaga. Depende
Kaya
lang
nga,
sa kanila.
pero under 7279.
Yes, sir.
Yes.
Ang sinasabi natin, baka itong this section might then give them another of compensation when 7279 has already attended to that.
Yes, sir. Tama yun.
Okay, but we can write the language properly so that it's not, that double compensation does not happen.
No double compensation.
No double compensation. Yeah. But which one will apply?
Yeah.
We have to specify which schedule will apply. Yeah. All right. Attorney May, is there anything else you would like to add? Is there anything else anybody would like to add? Okay, since there's none, thanks very much. We will, at this point, I think we have enough here. Solicitor Romero, please.
The case Attorney Mejia lost, Mr. Chairman.
Sakit mo naman magsalita.
He's a good friend, Mr. Chairman. I'm just kidding. NPC versus Maruhom, GR number 183297. Is that correct? That's all, Mr. Chairman.
Thank you very much for clarifying.
But it is actually the OSG that lost that case. So
yes,
we share the burden, Mr.
I
Chairman.
understand. Thank you for that information, Solicitor Romero. And with that, as I was saying, I think that we have enough here to work on to proceed to a working group, so that we will be in communication with all of you, especially the specific points that were raised here today and in the previous hearing. So with that, ladies and gentlemen, thank you for your assistance. We are adjourned.